right. Do we know if Senator Jude is going to join us or? All right. Okay. Hafadates Antiro, everyone. Good morning. Thank you for being here this morning. The purpose of today's gaming committee meeting is to receive comments, clarifications, and recommendations from the Casino Commission regarding the Governor's Executive Order number 25-002, which was signed and issued on May 30th, 2025. At this time, I would like to inform the public that this committee meeting is being recorded but not streamed live. It will, however, be posted on the legislature's Facebook page and YouTube channel at a later date. I would also like to ask everyone to please silence your electronic devices to minimize any disruptions. I am Senator Karina McGoffner from the 3rd Senatorial District, Chairwoman of the Senate Standing Committee on Gaming. I now call this meeting to order. Today is June 18, 2025, Wednesday. It is approximately 10:08 a.m. here at the Commonwealth Legislature, Capitol Hill, Saipan. Ellen Macaranas, please call the roll.
Senator Ronnie M. Calvo,
Present.
Senator Francisco Q. Cruz, Senator Jude U. Hofschneider, Senator Carl R. King Neighbors,
Here.
Senator Karina L. Magofnia,
Present.
Senator Donald M. Magnolia.
Present.
Madam Chair, there are 4 members present and 2 members absent.
Thank you, Devin. With 4 members present, we have the necessary number to conduct. With 4 members present, we meet the necessary quorum to conduct today's meeting. Let the record reflect that Senators Cruz and Hofschneiders are hereby excused. Before moving on to the next item on the agenda, I would also like to recognize our Legislative Bureau support staff who are here assisting us this morning. We have our Legal Counsel, Antoinette Villagomez, Legislative Assistant, Devin Macaranas, Sergeant at Arms, Ben Terlahi, IT, Jonathan Diaz, and IT, Jonathan Diaz. We now move on to the next item on the agenda, adoption of the agenda. Can I please get a motion to adopt today's agenda?
Motion to adopt today's agenda.
Thank you. A motion was offered and seconded. All those in favor say aye. Those opposed say nay. Motion carries. The agenda for today's meeting is hereby adopted. Thank you, members. Moving on to the next item on the agenda is public comment. The floor is now open for public comments. If anyone in the gallery wishes to provide comments relevant to today's agenda, please join us in the chamber. It appears to be none. Let the record reflect there's no one in the gallery to provide public comments for today's meeting. The public comment portion of this agenda is now closed. Moving on to new business, we have 2 items. We have the Casino Commission here with us today as our invited guest, and we have the Governor's Executive Order 25-002. Before we invite the Commission into the chamber, though, let me take this opportunity to briefly explain what the Executive Order is for those who may not be aware of its existence. On May 30th, 2025 of this year, Governor Palacios signed and issued an Executive Order number 2025-002. This executive order is basically to transfer authority for supervision of casino gaming from the Casino Commission to the Lottery Commission. The governor cited NMI Constitution Article 3, subsections 1 and 15, to substantiate the authority that allows him to issue the executive order. Under subsection 1, the executive power of the Commonwealth shall be vested in a governor who shall be responsible for the faithful execution of the laws, and subsection 15 permits the governor to make changes in the allocation of offices, agencies, and instrumentalities in their functions and duties that are necessary for efficient administration. At this time, we would like to invite the commissioners into the chamber. Chairman DeLeon Guerrero, please come in. And kindly introduce the commissioners who are here with you today and the senatorial district they represent. And if you have any opening remarks at this time, please feel free to proceed after the introduction of your members. Thank you.
Thank you, Madam Chair, and greetings to you and the honorable members of this committee. I am Edward De Leon Guerrero. I am the chairman of the Commonwealth Casino Commission. The commission is made up of 5 members, but we currently have 4 members. Tinian commissioner have not been appointed by the governor and remains vacant. I have on my left Mr. Mario Taitano. He is the secretary of the commission. We recently have a new member, Mr. Tomas Maglonia, appointed by Governor Palacios. He's currently the treasurer. Our vice president is off island and unable to join us here this morning. Madam Chair, this is a long story. Started back since 2015. It was really kind of a shock for us to see that governor would issue this executive order. But we appear before you to request that Executive Order 2025-002, which attempts to abolish the commission and transfer all of its functions, duties, and responsibility to the Lottery Commission, I think we feel that this executive order would delay the timely suitability review of the new operator. It would handicap the CNMI's ability to properly regulate the casino industry and would further frustrate the CNMI's efforts to improve our economic recovery, and is ultimately, in our opinion, not in the best interest of the Commonwealth. It is in this spirit that we appear before you, for your honorable committee, respectfully requesting your committee and the 24th NMI legislature to reject Executive Order 2025-002 within that 60-day period that's authorized by the Constitution, pursuant to your constitutional authority as vested in Article 2, Section 1, and as you alluded, Article 3, Section 15 of the Commonwealth Constitution. Madam Chair and members, the Commission, when it was established early 2015, we understood the magnitude of the responsibility of gaming, and we embarked on a very aggressive mission to recruit the necessary personnel, and we established different divisions, including a division of permit and licensing, because we have to permit and license all employees, a division of enforcement and investigations to do all the due diligence within the IPI. We also have the division of compliance to make sure that they comply with a lot of different requirements, and very important, the division of audit, because we have very good auditors, and we embarked on a long journey to send all of them to UNLV to receive the necessary training on how to regulate the casino industry. When we came back in early 2015, our former AG, Mike Ernest, helped us put together our regulations. Our regulations is 175-10. It's very meticulous, it's very thorough, and it's very complete, that would allow us to regulate the industry. All legitimate gaming operator wants to see a strong regulatory body in wherever they operate. No legitimate gaming operator wants to have gaming in an unregulated environment. It does not work. Like I said, we develop the necessary protocol, developing all the application forms for employee, key employee, vendor license, and so forth. And then we did something which we did not know prior to going to UNLV, which is this minimum internal control standards, better known as MIX. MIX is really kind of like the Bible on how the regulators carry out their functions. Because in the casino, which in my opinion is regulated even more than banks, every phase of casino operation has what we call standard operating procedures. The MIX contain an assembly of all the standard operating procedures. So anything having to do with enforcement, we bombard the enforcement staff. Anything having to do with the permit and licensing, that's what they bombard that. So when we walk into the casino, every phase of that casino, whether it's cashier, whether it's security, whether it's surveillance, whatever it is, has its own very specific elements that must be met. IPI must have their own internal control. It just cannot go below the CCC's approved mix. Now, the mix is normally not made public, at least not in its entirety, because it includes very sensitive information, for example, on cameras, where those cameras should be. It talks about the drops. It talks about when the drops would be picked up. And those are very, very critical information in regulatory regime. Now, we have been working very diligently since 2015, and it is our opinion that IPI really did very well in gaming. Where they really did not do very well was on the non-gaming aspect, primarily on labor, primarily on construction. And if you look at the casino license agreement, Section 2 says that the moment the license is issued, the Lottery Commission's authority over gaming ceases, and the Office of the Governor is responsible to enforce the terms and conditions of the agreement. And the CCC handles the gaming part. The casino, in my observation for the last 10 years, is perhaps the Commonwealth's first experiment with integrated resort, because it demanded under 1856 the construction of 2,000 new hotel rooms of 5-star quality, the investment of a minimum of $2 billion, construction of 100 million entertainment team and convention center, and so forth. Now, if you understand 5-star quality, the initial gaming, the casino license agreement was developed on 3 stages. The first stage is what considered initial gaming facility. That is the Garapan facility. Stage 2 comes in 2 phases, phase 1 and phase 2. That never took place. That's supposed to be somewhere in Marpi, Can Pacific, and that's where supposed to be the 2,000 rooms. Because initially, the Garapan facility was not counted on the 2,000 room or the $2 billion investment. That came in when they requested the 5th Amendment, and the Lottery Commission granted them. But the idea that the CCC, as I heard on the governor, the CCC has not done its job. I totally, after listening to his attorney, which to us by big surprise. In late 2020, I was the director of the CCC. I launched several complaints against IPI. That's the process. When IPI violates it, the director, working with the legal counsel, sets a complaint, and they have 15 days to rectify it. But I filed numerous complaints, including the non-payment of the license fee, the non-payment of the regulatory fee, the non-compliance with the order to reserve 3 months payroll, and a couple of other orders. They exercised their rights for a hearing. We did 2 evidentiary hearings. And at the end of this evidentiary hearing, we found them basically responsible to pay for the 15 million, to pay for the 3 million, and to pay, and we imposed a $6.6 million fine for not complying with the rules and regulations. Well, they appealed it to the Superior Court. It took the court time before they decided to hear, and they came out affirming our decision. IPI took it to the CNMI Supreme Court. And then the Supreme Court again only came up with their order, I think mid-2023, affirming our decision, letting IPI know that the license fee of 15 million is due since 2020 and accruing, but it reduced our 6.6 million fine down to 5 million because they thought that 1.6 during COVID is excusable. The problem that initiated all of this so-called due process, the license agreement, which basically is executed between the lottery and IPI, and attempted to carry through the intent of Public Law 1856. They had a provision in there called force majeure, kind of a French word for an act of God. They claim that Super Typhoon YouTube, they claim the COVID-19 pandemic are force majeure. And by the virtue of that being a force majeure, they are excused from performing the payment of regulatory fee and license fee. CCC disagreed. I said, look, the force majeure provision was not even on the law. That's only on the agreement. The law specifically provides that you pay this on a specific date by statute. So CCC cannot amend the statute. If you're not in agreement, we do not object if you go to the legislature and approach them to make whatever changes you want. We will not object to that. Because we agree that 15.5 million a year with nothing happening. The COVID did when the airport was completely closed, because you see, gaming here in Saipan never really target the local population. It always targets the visitor industry. So when the airport completely closed down, they absolutely have no more guests. And then to add over that, there's a numerous federal law that, and I'm not speaking on IPS behalf, but we understood what was the problem. Once the federal law came down and it prohibited CW, and then it prohibited CW for construction, and then they amended that to allow H2. And then later on, when they realized that they're abusing the H2 because there's a lot of Filipinos in there, they went in the federal government and removed the Filipino from authorized employee. I mean, it's just like, wow. But the federal came by and also amended that to remove the restriction. But it was like they're bumping not only environmental but legal issues. So when the Supreme Court concurred with our decision, and relative before that, they sought the federal court's permission to arbitrate. There's a section on the license agreement that also provides for arbitration, that whenever there's a disagreement, both parties should arbitrate. We claim that the arbitration provision does not apply to gaming violations, and it's very clear on the agreement. I believe that it will apply if it's having to do with construction or non-gaming. For the arbitration to arbitrate could be a supply issue problem. Maybe you're not able to meet the due deadline. You can probably arbitrate, but not on gaming-related violation. And it's clear on the license agreement. But they went ahead, and the federal court judge said, yes, it does apply. CCC, you have to arbitrate, or otherwise you contempt of court. So it ended up the 2AG went into Hawaii to arbitrate, and we took that decision to the Ninth Circuit Court because we think that it was not applicable. And the Ninth Circuit Court agreed with us. The arbitration was not applicable and reversed that order back. So we immediately notified the arbitrator, ceased all activity, because we don't want it to keep charging us when it's no longer necessary. Well, they took us to the U.S. Supreme Court. And knowing Supreme Court, it does not hear cases that does not have a national significance. So they denied the request for certiorari, which means it's dead. They turn around and file civil suit against us individually, and against us professionally, and against the governor. Those were two issues before the federal court right now, which I thought was dismissed in this stipulation, which we're still waiting for the AG to let us know whether it's dismissed or not. At any rate, Madam Chair and honorable members, the Commission looked at the license agreement, and I have nothing personal against the former or current members of the Lottery Commission. These people are just ex officio. They for some reason or other, if you are Secretary of Commerce, you are automatically a member of the lottery. If you're a DPS, you're automatically a member. And by statute, the Secretary of Finance is like the Secretary of the Lottery Commission. But they do not really have staff to work this through. But if you look at the agreement, very ambitious. Both 1856 is also very ambitious. But the imposition of a $20 million community benefit fund, it was not on the law. It was only on the license agreement. $20 million a year when there's no hotel, it is an unrealistic expectation. And like I said, we did not want to object to that because that's an agreement made by the Lottery Commission, and it's supposed to benefit the Commonwealth people. So, hey, more power. If you can put $20 million down, put $20 million down. But I have no idea how in God's name they can be able to comply. The 2,000 rooms, if you demand a 5-star quality, the 329 room in Garapan with the 15 villa, that requires over 4,000 employees. On the phase 1 and phase 2 for the 2,000 rooms, to maintain five-star quality, not just the facility, but the staffing, they would need between 12 to 15,000 employees. I don't know where the Commonwealth is going to find 12 to 15,000 employees. I thought it was a little too ambitious and probably very difficult to comply with. So at the end of the day, whether we proceed with Team King, and I'm sure you guys are reading up that, they went in on Chapter 11 for reorganization. IPI made some desperate move. They've been asking for negotiation since before all of this happened. But then at the end of the Supreme Court decision that gave us the final say, we asked our legal counsel if we can do what we call a motion for aid in judgment. We should have done that to the federal court, so we'll be a secured creditor. But we were told, just relax on this thing. But at this point in time, the way we're looking at it, the judgment against them from CCC still stand, but the collection mechanism, I think, might be something that is currently facing the thinking. But at any rate, they put out a bid. The bankruptcy court hired a group called Intrepid, and Intrepid took over the auctioning of IPI. And apparently they went around the world putting up IPI. Then they came back to us saying they need the license to be included, the casino license to be included into the estate to increase its value. Well, before that, we approached the AG's office, and I want to preface this by saying the Civil Division of the Office of Attorney General has been exemplary in its representation of the Commission. And we have been working really well with the former Assistant AG, Mike Ernest, also the former Civil Division Chief, John Laurie, and the current Chief of the Civil Division, Allison Nelson. These are really good people. They're good attorneys. They represent the Commission, and they let the Commission know what's happening. But since the filing of the bankruptcy, the Attorney General has assigned the solicitor section to represent the Commonwealth, including CCC. And what representation from this particular individual has been really not good. So at the time that the Supreme Court gave us the final say, we asked to proceed with the revocation. So with the assistance of Keisha and Allison, the CCC had a 2.5-day revocation hearing where IPI came in, and during this revocation hearing, they came in with some really heavier requests for negotiation, and they offered to pay 30 billion and make payment plans. The governor does not like any payment plan, and the Attorney General, I think, hates casino, and it's just there's no. So at the 11th hour on a Friday afternoon, I said, look, this particular lawyer is telling me that he's going to advise the Attorney General not to sign the stipulated agreement, of which Chief Nelson has been helping us all along to try to settle this. It was ready to be settled. But one lawyer says he's going to recommend to the Attorney General not to sign the legal sufficiency. So I said to IPI, I am sorry, if the AG does not sign, we have no agreement. We will proceed Monday to revoke your license. It was the revocation hearing is completed. All we're doing now is deliberation to revoke. And then Friday afternoon, right after I told them, in just a few hours, they filed for bankruptcy, Chapter 11 protection. By Sunday, I got a notice on the email from the federal court for a stay, so that the Monday proceeding to revoke cannot continue. You must stay. We asked this lawyer representing us, we would like for you to seek the federal court's approval, a petition to lift the stay. He looks at it, and his response just about, really surprises me to have your lawyer tell you, no, we're not going to do it. It's going to take too much time, too many motions, and we feel it's not going to succeed, and you may get sanctioned by the district court. I said, this is my own attorney telling us, asking, please ask the court to lift the stay so we can revoke the license. And he said, no, we're not going to do it.
Thank you. I just wanted to clarify, when you said you're talking about your attorney, is this the solicitor?
Yes,
And that individual's name is
Robert Glass.
Robert Glass. And then prior to your discussion, you said that you guys were getting assistance,
From Allison Nelson.
which is part of the civil division.
She's the
under
chief of the civil division.
Correct. At what juncture, at what date did you stop receiving the assistance from Ms. Nelson and started receiving from Mr.
You know, the
Wentz?
Chief Nelson was representing the executive director,
Mhm.
and Solicitor General is supposedly representing the entire Commonwealth.
Okay.
And when he starts saying that, no, I'm going to recommend to the AG, civil division pulls back.
And do you recall around what time? I mean, it doesn't have to be a direct date, just within a month.
It was the same day that they filed for petition. I mean, for the bankruptcy. I can get the date to you.
Okay.
The
Thank you.
time that they filed the bankruptcy, Chapter 11, the
Okay.
protection.
So once Attorney Glass stepped in, it was his.
He was there prior to that statement, going before the commission's monthly meeting, telling the commission, do not, negotiate anymore, terminate this license, before he was even assigned to represent us.
Okay.
So he's already very biased coming into the picture.
Understood.
And like I said, and one of his conditions was the payment of $30 million. IPI is saying our parent company in Hong Kong would wire it to CNMI Treasury. I said, nope, you cannot do that. You have to wire it to IPI CNMI and let IPI CNMI pay. I contacted Justin Rowling, the attorney for Revenue and Tax. I said, is there any restrictions from a company wiring you $30 million? He goes, absolutely not. Bring it over. The CNMI needs that $30 million. And I did looked around with Alison a little bit, and I said, what was the logic behind this guy's insistence that it must be directly to IPI, not to the CNMI Treasury? And there was a term called clawback. It means that if you deposit 30 million and then they later file for bankruptcy, they have a right to take it back. I said, so what? If they deposit, at least there's good intentions that they're going to do it. Let them do the effort to take it back. But it was just like, we don't know what we're talking about. So, but he's already I can give you, like, set the date of.
No problem. No problem. At any time that
yeah.
you guys can provide it to the committee.
So
but please continue on with your.
when IPI just gave up, it says, look, we don't even want to include the license anymore. We just want to sell the building and our leasehold. We turned back again to them. It says, look, the license is no longer part of the package. Can you please file a petition to lift the stay? My God, this letter back to me is going, I don't know how many times we have to tell you, we are not going to ask to lift the stay for you. If you insist on doing it, get your own attorney at your own cost, your own private attorney. No, this is complete contradiction with what Manibusan told me several years ago, that by constitution, only the Attorney General's office can represent CCC. Now, for this solicitor to tell me that we don't want to represent you, go get your own private attorney, is a complete contradictory statement. But we're not going to object to him, because later on, that letter is going to bite them. I'm going to use that letter later on when we try to get our own attorney in the future. So now that we could not, for the governor to say, after consulting with the attorneys, he couldn't figure out why we could not make the hard decisions. It's like, excuse me. Somebody said that. I said, God, I wish I did not see that interview. How could the same attorney probably that drafted the EO, the executive order? How in God's name can you say that we couldn't make the hard decision when it was your lawyer that refuses to ask the federal court to lift the stay? I mean, it's really upsetting, but there's nothing we can do. CCC have no money, and we cannot hire our own lawyer. And the Constitution is being violated, in my opinion. And the attorney-client relationship, I think, is an issue for the bar maybe to take a look at in the future. What kind of assembling information down to, because you cannot have your lawyer that refuses to represent you. And this is where I thought, Madam Chair and members of this honorable committee, that the rush on the legislative initiative to make an elected attorney general was perhaps a rush job, because that office of attorney general should be under the office of the governor. It doesn't matter who the governor is. and have an elected prosecutor to fully prosecute all violations of law. You cannot have a shadow governor, which even if the governor signs a document, if the AG doesn't sign, it doesn't move. It does not work. But it needs legislative approval to change that constitution, make an elected district attorney, and let this entity prosecute all violations of law, but remove all non-criminal back to the office. The governor needs an office of attorney general within his office. Right now, there's still governor operating in the Commonwealth, in my opinion. No official documents can ever proceed without having two signatures on that. So going back to this, we are now responsible for all of this. It really surprises me, and it reminded me, if I was to make an analogy in reference to Governor Pelosi's blame, this is like a fire chief who cuts funding to the fire department, blocks access to the hydrant, and then blames the firefighters when the building burns down. The CCC acted, we enforced the rules, but our ability to finish the job was blocked because we were constrained by judicial process, or at least by the Attorney General's office not only refusing to assist, but giving veiled threats of sanctions should the CCC try and do its job. All the while, the governor failed to carry out his own responsibility under Section 2 of the Casino License Agreement, and now seeks to dissolve the one agency that fulfilled its role. That's not accountability. That's rewriting the story to hide the real failures. And I'm not here, Madam Chair, to badmouth the Lottery Commission, because these people are both former and present. They're good people. They have good intentions. But the executive order is not the right way to streamline. You're not streamlining anything. And on the cost, since 2023, there are no more personnel, and the only thing we're incurring now is the rental and the commissioners, and that's it. We cut all expenses have been stopped. And even your appropriations, which was properly enacted by the legislature, signed into law by the governor, and this AG turns around and says it's unlawful because you have no money given to you under personnel in Schedule A. We never asked for Schedule A. We never asked for personnel. We asked for Schedule B that the legislature appropriated. But they conveniently decided you have zero on the Schedule A. Therefore, you cannot get paid. I don't understand the logic. Even my young child can say they never asked for that. It was a whole page 18 of the budget, which is Schedule B. And then to say, turn around and say you have no public purpose. In my opinion, only the legislature decides that public purpose issue, not the Attorney General's office. So, obviously, in my opinion, there's a bias against gaming. And I heard recently that there is some difficulty in terms of the agreement between Team King, the entity who won the bid, with Public Land. I tried to get the information on what exactly is the problem. There was hesitation to talk about, but I heard that it may be that Public Land is insisting of $189 million payment to be deposited at DPL. I have not verified that with Public Land, but that's something you may want to inquire. Because if you're going to demand this new company that just won the bid to put in over $100 million of cash, either it's a form of bonding or whatever, it's a sure way to kill the industry. You know, I also asked the AG to please verify during the negotiation about this $12.9 million bid with assumption of certain liability. I asked repeatedly, can somebody please share with us what are those assumptions? What are those liability? Did they include the license agreement? Did they include the regulatory fee? Did they include the fines? No response. So we ended up.
When you said there was a 12.9 assumption or Say it again. There was a
The
12.9.
winning bid is 12,900,000
Okay.
with assumption of certain liabilities.
And this bid was from whom?
Team King,
Team King. Okay.
CNMI LLC.
Okay. And you weren't privy to the language in the.
Yeah, I went. We went down and got it ourselves, and we also got a copy from the opposing counsel. I just. I sent out to Allison. Ended up sending me the copy of the stipulation after I already got it from opposing counsel. The stipulation was, which to be on section 6, I guess it says the Casino Commission hereby agrees. Excuse me. She says he agreed when you never consulted with us, even though it actually it helped us out, but it should have at least let us know that we agreed before the media was here asking me, so what do you think? I said, can I read first the stipulation because I have no idea what's in the stipulation.
So just to clarify, the stipulation was made, and you guys weren't aware of the language in the
No.
stipulation.
No. Like I said, after reading it, it was okay to CCC. It was okay, but at least let us know after our repeated requests. Can you please let us know? And then one of his initial response was, well, they are assigned lawyers, so you talk to your assigned lawyer. Don't talk to me. When we asked that assigned lawyer, he says, oh, that's another lawyer handling the bankruptcy. It's like, I don't know, how do you say this? But CCC is frustrated. We are trying our very best to implement and to enforce Public Law 1856, Public Law 1924, and the most recent amendment 21-38. 21-38 allows us to issue the license, and it also recognizes the enforcement authority of CCC. So CCC is actually officially an enforcement entity with the right to arrest and so forth. But to allow that, in the law itself, we identified crimes, and we identified penalties attached to those crimes, and the CCC is the enforcement entity. That's why we send we send down to a point, Madam Chair and members. IPI procured one of the most sophisticated security surveillance system from Germany, the Dahlmeier system. There are, I cannot tell you exactly how many because it's supposed to be confidential, but there are more than 3,000 cameras down there that can can count your mustache from the eye in the sky. And we send our people, 6 of them, to Germany along with IPI to learn the system, to understand the system, and come back. So we're very, very trained, very, very well. And it's just every phase of the process we have staff. But the most complicated part was the mix, the minimum internal control standards. This is over 300-page document. And this is something that any regulator must understand. It's your Bible. And it doesn't matter whether you're in Tenyan or Rota. Those gaming commission must have minimum internal control standards. And if they don't, I suggest they start working on it. But it's also something that should not be necessarily made public, because it talks about movement of funds, and you don't want the potential robbers to look at the system and see for every banks of slot machines there are X number of stationary camera and or pen and tilt cameras, and we have to approve the layout of the security, and we have to approve how it is implemented. Now, if you make that public, and they know what time you're going to drop the money, and they know your routing to the count room, it doesn't take a rocket scientist to know that if you want to plan a heist, that's it. Start with the mix, because you would know. And also as simple as, what is your business day? If somebody comes up and asks IPI, what's your business day? That should trigger a suspicious activity report. And normally it's a why would it suspect? Because if you are playing and you exceed like $3,000 threshold on a one business day, you have to report. So if you're coming close to that 3,000, you can wait until the next business day and then continue again. It comes back to zero. So it's a way to layer as part of the anti-money laundering provisions. But Madam Chair, the CCC staff went through some rigorous training under Title 31. This is the Bank Secrecy Act, and we went at length looking at the anti-money laundering provisions. And in fact, we insisted on IPI mandating immediate training on the anti-money laundering, and we require every employee as part of the licensing agreement to have it certified that you have taken those training. And we set the training in 3 stages. One, the lower level, all the way up to key employee, which is a very intensive training. And IPI did really well in a sense that they hired Kenneth Hines, a retired IRS agent that oversaw the Tinian investigations on the Tinian, Kenneth Hines, and Vincent, Gregory Lisa. They hired both, were retired, to help IPI set its anti-money laundering policy. And we work with them to make sure that every employee of IPI goes through those training before we issue them their permits. And one of the people that went through that training is the current Secretary of Commerce, which I'm happy that at least she has exposure to the anti-money laundering and the issues that IPI face. But we're here to answer any questions that you may have, but I can assure you that this executive order is the wrong move, and his explanation from what I saw on the media is absolutely incorrect and false. And there's a statement on that executive order that is legally very dangerous when he says that he's terminating the commissioners for cause. That word cause has a constitutional or statutory definition, and the governor failed to list even one. And that exposes the Commonwealth to potential liability. And the CCC is not sitting idle on this thing. We're looking at this thing, hoping that we do not have to exercise that right if the legislature rejects this. But thank you, Madam Chair. We're here to answer any questions that any member may have.
Sidus Masi, Chairman, we really appreciate the extensive and comprehensive backstory and timeline that you have provided the members. Some of us are new here at the legislature, and then also just knowing and understanding what had transpired from the beginning to where we are now. So thank you very much for that information. Just for quick clarification, when your attorney told you that they weren't going to be able to file the motion to lift the stay, did you seek the Attorney General Manabusan's opinion about it, or was he aware that that's what was going
He
on?
was CC'd on that transmission that was sent to me.
Got it.
I was waiting for him to comment. He didn't.
So no comments
No.
or
In fact, on the last 2 months meeting, every time I request for an attorney present during the meeting through the LSR,
Mhm.
he writes me back saying, no, commission, the casino, there's no casino anymore. And we're not going to represent you, so we have no attorney.
Okay.
Now, keep in mind that it's his own civil divisions that have been helping us all the way to
Yes.
2024. We went through all of this with his own office. And the revocation hearing was on January, February, March of 2024. We've been working with his own at arbitration. And then for him to say, well, there's no casino since 2020, therefore we have no attorney available.
Okay.
So it's a dereliction of aegis duty as required by the Constitution.
Okay. Thank you. At this time, I open the floor for the members to ask their questions, and I now recognize Senator Donald.
Thank you, Chair. Good morning, Commissioners. Before I go into my questions, can you just elaborate what came out in the news yesterday regarding the liability insurance? And I see that there's a deadline for tomorrow, and so what? Can you provide the different scenarios as to what will happen?
I
That's
am not an attorney for them, but from reading what I read on the paper with you, there has to be a requirement to have insurance active, and apparently the insurance of the facility has expired. And I believe part of the expiration is that they believe that the sale would have consummated already, and the new owner would assume all of the liability. But because it's supposed to be a June 13 status conference to say, update us on your payment of the $12 million. How does that $12 million disperse? But then they postponed the June 13 to June 27. And then in the process, the insurance for the facility have expired. So the judge is saying you need to renew that insurance right away, or there's nothing to talk about. Now, based on that based on that judge's statement, if it was true, it appears that if they, even though Attorney Choi was has requested the court for additional time, so the judge did give him time if he has any demonstrable evidence that he's trying to get insurance. It may extend that beyond June 20. But if the judge is saying that if there's no insurance, and the agreement between Tim King and Public Land does not consummate soon, there's a possibility he may just say Chapter 11 protection is no more. Gone. Which means IPI, there's no more bankruptcy. Everybody have to go back in and try to collect. Most likely there will be a Chapter 7, which is complete liquidation. And I can assure you that if there's complete liquidation, CCC will no longer need permission from the federal court to lift the stay. We will proceed with the deliberation, revoke the license, and then come back and reissue a new license availability. Maybe not at the site, but available license. And this is, but we know that there are constraints within the system right now. And I do not know why at the time when our economy is really suffering. Oh, by the way, when I asked this lawyer from solicitor that we're working with the legislature, since we're asked what you need to do, and I've been presenting solutions on how to do it, he wrote me a letter saying that's not the responsibility of the commission. That we're regulators, we're not policymakers. I had to remind him that Title 4 of the Commonwealth Code lists us all for responsibility, including working with the legislation. And he says that it's not, basically says it's none of your business to be doing that. And by the way, AG will not provide them either because they have their own attorney. Like, wow. Thank you very much for nothing. You know? But I hope I answered that. There's some gray area here. It appears from what I'm hearing that Tim King, with this assumption of certain liabilities, is trying to have the leasehold transfer from IPI to Tim King. I believe DPL, and I have not spoken to DPL, is concerned too about bonding. By the way, Public Law 21-38 also gave CCC authority to impose bonding. But I think that there's some disagreement between Public Land and Tim King on the transfer of the leasehold. And that's what's holding up the consummation of the sale, the 12.9 million. If the 12.9 million is paid up, all of this issue of insurance will no longer be an issue because the new owner would pay the insurance. The new owner would take care of all of the costs. But the new owner hasn't stepped in yet. So IPI, which does not have money at this point, is still expected to pay the security, which apparently have not been paid for a month, and so forth. But even us, Madam Chair and members, CCC does not have any staff since January 2023. We've been just volunteering our commission, to keep this going. Because if we throw in the towel, it's over. And we're hanging in there to see. Let's help the Commonwealth get up its feet. Our term is up in April anyway. And there's no renewal, and the governor just appointed a new one, and he needs to appoint one from Tinian. And he told me that Tinian leadership asked him not to appoint. I said, okay, I'm not gonna get involved in that one. And then 3 of the one from Saipan would need to be renewed come April. So this is a very difficult transition, but we cannot drop the ball now. The new people need to come in. They need to have whatever regulatory regime or infrastructure that we have in place picked up and improve. But I know that since this is the Commonwealth's first experiment with integrated resort, it involves tremendous amount of non-gaming. And I can understand why Section 2 says that the governor is responsible to enforce the terms and conditions of this agreement, because CCC does not do building code, public works. and public works fall under the jurisdiction of the governor. And we do not do quite a lot of the other issues that IPI is confronting problem with. We handle gaming. Anything having to do with gaming, CCC would do it. CCC would deal with that. The gaming machines, gaming regulators, permitting, anything having to do with gaming operations, CCC would do. But any outside labor, we have. And by the way, we invite Department of Labor. Go and enforce, and we'll back you up. We're your secondary. They have lawyers at IPI. The moment we touch labor, they say, "Sir, you have no jurisdiction on that." But if the labor department does it, we back them up. We even went because the CNMI labor says they lost jurisdiction because of the number of employees that IPI have. So we went to Guam trying to see the labor department, saying, "What can we do?" That time Dean Tenorio was still U.S. labor here. We asked him too, "Can you help out?" He goes, "Lanya, can you help us out?" I said, "We're not labor. You do it, we help you out, we back you up." We go to the public works, said, "Can you please do your job?" We go to the fire department and said, "Hey, I need the fire permit. I'm not gonna allow the IPA to open without a fire permit." So they send on 2 or 3 people, and they said, "Well, did you give them a fire permit before we allowed to open?" They said, "Yeah, we give them a." And I went down to see where they were. Oh, I felt sorry for this. They put them in a warehouse in the back. I called up IPA and said, "This is not acceptable. These people have to come up a little bit, give them an air-conditioned room, and so forth." And I asked them, I said, "If there's a fire, what do you do?" "We call 911. I said, "You're the fire department here, station 24/7. You're going to call 911? "Yeah, Lanya, what are we going to do here? This is a big building." So I said, "Okay, that is your, I'm not going to interfere with your operation." We did this, Madam Chair. In fact, before we allow, our regulation allows only one facility to open at one time. So when the T Galleria closed, the IPR opened. That facility in Yarpan is sometimes called Imperial Pacific Resort. Sometimes it's called Imperial Palace. Sometimes called Initial Gaming Facility. So if you hear those, it's the same building. Imperial Palace, Initial Gaming Facility, Imperial Resort, Imperial Pacific Resort. It has 329 rooms, not yet, it's 60% complete, and you have 15 villas that's already complete. And that villa, I can assure you, facility-wise, is equal to or better than the VIP room in Vegas, in Macau, or in Singapore. I've been in a VIP room, I've seen it. The one, the 15 villas down there at IPI, is up to par with the 5-star status. The only thing it needs now would be the staffing. How do you staff that? And I'm glad that they have security, because that's a very expensive place. I think they estimated 300 million to begin with, and I believe that the last estimate was like it's already over 400 million. And the latest information I received was that it would take about 150 to 200 million more to finish. And
Chairman,
this,
sorry, I don't mean to interrupt. And I know we're going to be going to recess pretty soon, and so I just want to ask one more question before we go into recess, and then continue on whenever the members decide to come back. So can you just explain what are the next steps should Team King take over? What's going to be needed of the commission to start back up? What is the cost going to look like in terms of starting back up, hiring back the inspectors or the investigators, the compliance officers, all of that? What does that look like once everything has been finalized with the court? If the court ends up dismissing the case and this moves forward with Team King, or I mean, and the issue with DPL gets resolved, what does that look like in terms of starting back up?
If we take the route that the issue with DPL has been resolved, IPI IPI owes CCC 17 million pre-petition and 6 million post-petition. Now this is critical because the pre-petition, you fall in under those considered possible pro rata distribution of the 12 million. And we don't know if we're going to get a penny on the dollar or nothing at all. Or if we go to this assumption of certain liabilities, which we may get something. But at any rate, it appears the last information I have from this council that I was referring to says that the CCC reserves the right to cure the deficiency through negotiation with Tim King. So I'm saying that IPI owes the CCC $20 million. And our discussion with Tim King would be, how do you cure that? Obviously, we're not going to expect upfront payment, but some kind of Public Law 19-24 says 3,150,000 a year. So we are going to ask that Tim King deposit application fee, and also pay that annual at least 1 year payment to allow the CCC to rehire back those trained people that are sitting behind waiting to be called back. And the application fee would be the one that would be readily that we can consult with professional investigators right off the bat. While we are recruiting our own staff, we'll be negotiating with professional investigators to go abroad and look at Tim King. Now, Tim King, I might add, there's a guy named Hiroshi Haneda. He's the CEO of the group of Japanese banks. This group have already participated with IPI in previous years. They committed $500 million when I was director of CCC, when I asked IPI to show proof of their financial suitability. They produced a document, an agreement between this Hiroshi's team of banks and IPI to commit $500 million. To a subsequent annual report, it appears that they have already used $150 million of that in the construction of IPI. So there's $350 million available. That's the amount that negotiations, even with him and CCC, saying that we have $350 million, we're ready to put in that facility, finish it. And in my initial negotiation with Mr. Rossi, I'm saying we cannot proceed unless you deal with the regulatory fees and the license fee. And his comment to me was, that's IPI's problem. They are not going to handle the license fee or the regulatory fee. So I'm saying that if you don't handle those, then there's nothing to talk about, because, and that's when, this is the same company that restructured their name to Tim King. So the person in there is Hiroshi Haneda, is Japanese, and is being backed up by Japanese banks. It's not your retail bank, but it's a special bank that works with problem businesses that then they come in and rescue. So it appears on paper that they have over $350 million. I would suggest that, and I'm not DPL and I don't want to interfere with their process, but as I told the governor during the last negotiation, where we have all the lawyers on one table, I was saying my primary concern at this point is let IPI finish the building. Let them finish the building safely. And two, let them negotiate how they're going to pay everybody that they owe. There will be no dismissal. You may make payment arrangements. It may go further up the line, but you have to pay. And at that point, this was in May last year, the governor says, and yeah, what? We'll both die before we see the money. We have to stop chasing butterflies. You know, it's not there. And we have this attorney that says, no, we're going to file for Chapter 7, complete liquidation. I said, no, you cannot. I mean, they fought us for 3.5 years. You think they're going to give up that easy? And this attorney, Glass, looked at me and said, sir, this is not IPI making any decision more. This is the federal court. Well, it's over a year now. And now it appears that we may go back to starting point. Wasted all this time when they reached out to us saying, can we make arrangements? Either this executive, no, this AG is in support of that. And I just, like I said, hey, plus the fact that nobody's supporting and we're not even getting paid. It's like, Jesus Christ, this is crazy. I have family members asking me, I think you need help mentally. Should drop this ball and move on. And you know, oftentimes that seems to be the easiest way out, but it's not the best way for our Commonwealth. Whoever the CCC is, they have a fiduciary duty to make sure that we do what is right, whether we carry out the intent of 1856. You know, and this is intended to save the Commonwealth Public Pension Program. We cannot walk away from it. We need to, whoever's sitting in our positions, in our chairs, need to take the same type of passion to help the Commonwealth and do our due diligence. All of these issues about corruptions under the table, those are nonsense. You know, during the earlier days, I had FBI down the office almost every day that I accused them of having to time in because they're always down there, but there's just nothing to look at. And we tried our best to make sure that this casino regulations is implemented and that the minimum internal control standards is complied with. And like I said, for our members from Rota and Tinian, I would urge that since we're in this discussion, that your gaming regulators ought to consider establishing the minimum internal control standards and establish that for your area. Because our areas, when we establish it, we establish our regulations after Nevada's platform. We establish our mix after the Missouri platform, because you have to have a platform that you extract from. So we use Missouri for the mix, and we use Nevada for the regs. And I know that I think Rhoda used Tinian, and Tinian used a mixture of Nevada and New Jersey. Yeah, and I looked at yours too, trying to figure out. Tinian asked us too for help, and I might say that several times over the years we train people from Tinian, and we actually send them in, and we have 1 week intensive training. And I have them come up and talk to me that they've been down for 15 years, they never had that exposure.
Thank you. Madam Chair, I'll yield at this time with
Okay.
the understanding that we'll come back later.
Yes, thank you, Senator Donald, and thank you, Chairman, for your explanation. We'll take one more question from Senator Carl before we go into recess, and we will rise back this afternoon at 3 p.m. Thank you.
Thank you, Madam Chair, and thank you, Commissioners, for being here today. The one question, I guess, at the core of this executive order is, what specific challenges do you foresee in the transition of responsibilities from the Commonwealth to the Commonwealth Lottery Commission from the CCC?
As far as the transition, I think that the order is basically saying you guys are all fired.
No, what issues do you foresee might arise if
Oh,
the executive order it goes through?
I was trying to think about the transition.
Yeah.
And so in other words, if you get rid of the people that needs to get transition, it's a problem. They already issued a letter to me saying, give me the key, we want to do an inventory of all your assets and all that. And it's like, I'm not responding to that because there's a lot of very sensitive information in that building. When we do our due diligence and we investigate the people, all of the confidential files are in there, and they have expectations that we keep those confidential. Before we were actually thinking about departing, I asked the Attorney General's office, the public auditor, the office of the governor, for an office or space for us to relocate all of this confidential stuff. We were told there's no space. I went to our assigned attorney, Keisha, and I said, it will be reckless for us to leave. I would like to shred all of those documents, so the confidential document. The employee document we can transfer to personnel. But the IPI document, I want to shred it because there's some very, very sensitive information that we did on every employee. I was advised you cannot do that. You have to keep it 6 years after you decide to close. So I said, okay, so what do? I was advised by this our assigned counsel, write a letter to the governor and say, here's the key and here's the file, good luck. I think that's not prudent. That's reckless way to do it. So going back to your question, what can CCC and Lottery Commission do?
Oh no, my question is, what issues do you see might arise if the EO goes through?
I am not quite sure how the Lottery Commission intends to conduct the due diligence. I suppose that they can do it like the initial Lottery Commission did, which is hire consultants and go out and do the initial there's two investigations. One was they look at the criminal background, the probity background, and then the other investigation was the financial plan. In the case of IPI, we have, I think, B2G that did the criminal background, and another group called Innovation Group that did the business plan review. And by the way, the business plan review requires 2 million visitors a year for IPI to be able to break even. So that will be done for Tim King. But where you come in and look at every employees of Tim King, every vendor that's going to sell gaming equipment, every aspect of the minimum internal control, cannot, in my opinion, if the lottery commission intends to implement the minimum total control by themselves. They would have to hire back people and but I find that really difficult because these people have their own departments to run.
Correct.
You know, I cannot imagine a 24/7. This is a 24/7 industry. It doesn't stop. Um, that's why in the most recent law it says that we're considered critical employee for during austerity because we don't close. We stay with the gaming. So on the issue of doing the due diligence on Team King, I'm sure the Lottery Commission can do it like they did initially. But on the issue of implementing the license regulations, they would need help. And I'm not quite sure how they could do that.
Understood.
And it's a very sensitive responsibility because none of the commissioners, there's a lot of restrictions on what commissioners can do with the industry. And I don't know if DPS or Commerce or Finance have any I'm not aware of any.
So I would like to thank you. I apologize to cut you
Yeah.
short, but thank you for the answer. I know we're kind of running low on time, but I really would like to circle back and flesh out a lot of the details of this EO and some of your concerns when we come back from recess.
Okay.
And with that, I yield, Chair.
Thank you, Senator, and thank you, Chairman, for providing some answers to Senator Carl. At this time, if there are no objections from the members, I would like to call a recess. So can I get a motion to go into recess and rise back this afternoon at 3 p.m.?
But Chair, should we be back? Should we be back at
Yes,
3?
please, because we will still have our Q&A
Yeah.
session.
Can I recommend that you invite the
Oh,
Lottery Commission members to come in too, so we can join with them and talk with them too. The Lottery
I did invite the Lottery Commission to come actually this afternoon, but they had a conflict in schedule,
Okay.
so they won't be able to come this afternoon. But we do intend to invite them so that we can also hear from them. I guess we don't need to do a motion to go into recess, so we'll go to we are now going into recess at 11:14 a.m. Thank you, members, and we will rise back this afternoon at 3 p.m. Thank you.